Good morning, everyone. This is the Committee on Professional Conduct. I'm Doug Aguilera. It is, in fact, the September 19th, 2025 Committee on Professional Conduct meeting. The CBA welcomes and encourages public participation throughout the meeting. Members of the public have an opportunity to provide comment in person or via WebEx platform. Instructions on how to make a public comment will be provided whenever a comment period is open. You will be allotted up to 5 minutes for public comment. At this time, I'd like to turn the meeting over to Ms. Reed to establish a quorum.
Member Aguilera,
Here.
Member Corrigan,
Nancy Corrigan, present.
Member Hines,
Present.
Member Lotta,
Present.
Member Lynn,
Here.
and Mr. Rayful.
Here.
We have a quorum.
Thank you, Ms. Reed. The CBA's mission is to protect consumers by ensuring only qualified licensees practice public accountancy in accordance with established professional standards. This mission is derived from the statutory requirement that protection of the public shall be the highest priority for the California Board of Accountancy in exercising its licensing, regulatory, and disciplinary functions. Whenever the protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. Moving on to our agenda, are there any public comments for items not on the agenda? Seeing none here in Burbank, it's my understanding at this time there is no one online, no public members online.
That's correct.
So I will continue on to item number 2, which is to approve the minutes of the July 17th, 2025 Committee on Professional Conduct.
I move approval as distributed.
Thank you, Mr. Rayful. Can I get a second? Ms. Corrigan, thank you.
Yes, I'll second that.
And are there any comments? Any comments here in Burbank? Ms. Reed, will you please take roll?
Member Aguilera,
Yes.
Member Corrigan,
Yes.
Member Hines,
Yes.
Member Lotta,
Yes.
Member Lynn,
Yes.
and Member Rayful.
Yes.
Motion carries.
Thank you, Ms. Reed. That brings us to item 3 on our agenda, which is review and possible approval of policy direction regarding continuing education provider requirements, including the use of artificial intelligence. And Ms. Benedict will present for us. Thank you.
Thank you, Chair Aguilera. It's a heavy mic. I am Sarah Benedict, and I'm the manager of the License Renewal and Continuing Competency Unit. The purpose of this agenda item is to provide the CPC and the CBA with the opportunity to discuss and possibly approve changes in policy related to continuing education, or CE, for inclusion in a future rulemaking package. The recommendations relate to CE provider requirements, and while none of the recommendations are specific to artificial intelligence, several of them go towards safeguarding the quality of CE from the potential negative impacts of AI. The agenda item aligns with Goal 2 of our current strategic plan, as noted on page 1. In March 2024, then CBA President Mr. Rosenbaum appointed Mr. Aguilera and Ms. Batchelor to work closely with staff as a CE work group to develop proposals and ideas for CBA consideration. I am going to refer to the CE work group as the work group going forward. The work group met on 3 occasions and discussed various CE regulation topics. Each of the topics will be brought to the CBA for discussion, culminating in an agenda item for consideration to initiate a rulemaking. I want to extend my gratitude to Mr. Aguilera and Ms. Batchelor for their time and expertise. This item will focus on policy directions related to CE provider requirements. NASPA jointly publishes the Statement on Standards for Continuing Professional Education Programs with AICPA, which I will refer to as the standards. Staff used the standards as a resource when developing the recommendations in this item. The standards provide a framework for the development, presentation, measurement, and reporting of CE. It is important to note that the standards are currently undergoing revisions, and exposure draft was released on Wednesday. Staff will review the exposure draft to determine if any policy directions should be reconsidered. And of course, the exposure draft will also be brought to you in November for an opportunity to provide input to NASBA and AICPA on the draft. Now let's turn our attention to the policy direction recommendations related to CE providers. A few of the more significant changes that I'm going to touch on include learning objectives, course quality, participant engagement, and through course tests. I'll begin with learning objectives. Staff recommends additional transparency to assist licensees when selecting CE. The recommendation to require CE providers to inform potential participants on the delivery mode, the amount of CE credit they may earn, the field of study, description of course, and knowledge level. Several of the policy direction recommendations directly address course quality. While these recommendations would apply to all CE course providers, they are also meant to safeguard CE from potential negative impacts of AI. Let's go through these recommendations. Course content must be reviewed by a human subject matter expert other than those who developed the course. This is meant to ensure the course is accurate, current, and addresses the stated learning objectives. This requirement is also meant to guard against AI hallucinations. Course materials must be current and include the publication, revision, or review date. For example, if a course provided attendees with professional standards, the course provider must ensure that they are the most up-to-date version. The inclusion of the publication, revision, or review date will help licensees know if they are referencing the most current version, even after the CE. Consistent with this idea of currency, course content must be reviewed at least every 2 years and revised as necessary. When using a human instructor, they must be competent and current in the subject matter through training, education, and/or expertise. Course providers must issue an end-of-course evaluation to all participants within 10 days of their course completion and have a process to review the act upon the feedback. The minimum requirements for the course evaluation are listed on page 5 and also go towards identifying any accuracies that AI could have introduced. All right, turning our attention to participant engagement, which also directly relates to course quality, staff recommends CE providers require one element of engagement related to course content during each hour of the course. Courses less than 1/2 hour would need to have one element of engagement. Participant engagement can include a group discussion, review questions, hands-on activities, etc. Current regulations require attendance monitoring for group internet-based programs. The attendance monitoring may also serve as participant engagement as long as it is related to course content. The next recommendation is to allow course providers to administer through course tests instead of end-of-course tests. Self-study courses require an end-of-course test and a passing score. This recommendation gives CE course providers the flexibility in choosing how they would like to administer the already required course test. The additional recommendations in the item include requiring a technology failure policy, requiring providers to resolve or disclose conflicts of interest, adding a clarifying statement that self-certification of attendance and completion is not sufficient, requiring course providers to retain documentation demonstrating how the provider determined how much CE credit a course will award for successful completion, requiring providers to provide participants with a certificate of completion within 60 days of course completion, and adding language to the current instructor availability requirement that requires a human instructor for all synchronous CE courses. Another recommendation directly related to AI. To conclude, staff recommends the CBA approve the policy directions as detailed in this item for inclusion in a future rulemaking to address CE course provider requirements. I will now turn it back over to Chair Aguilera, and I'm happy to answer any member questions.
Thank you, Ms. Benedict. Are there any questions from the board or from the committee members? Mr. Rafel?
Thank you for your presentation. I have two questions. Really, the first one is you had mentioned early on in your presentation about potential negative aspects of AI. Just generically, what do you think those are?
It's hard to answer that because there's just so many unknowns, but some things that we might see are referencing documents that don't exist or giving false information about the documentation. It might also be answering questions incorrectly, based on hallucinations.
And you mean answers given by someone taking the test or a test?
I'm sorry, what was that?
You said referring to false information. So who's going to determine whether it's fake or not?
The subject matter expert. So for example, we do know that AI has come up with case law that doesn't exist. Not necessarily in the CPA profession, but it has happened.
Right.
So we would want a human expert to review any content that has been created by AI to make sure that it's accurate and that it's the most current information.
And that would be the responsibility of the course provider or a CBA staff member?
Course provider.
Okay. Okay. My second question is, you talked in your presentation about monitoring attendees during a course. I assume that would mean that everybody would be required to have their video on so that whoever the course providers could actually see the person watching it.
That is a requirement in the NASBA CE standards for two-way enabled video conferences. It's not spelled out necessarily in the CBA requirements, but it could be something like a poll, like, for example, has anybody ever done this type of engagement before? Yes or no? You answer this poll online.
Yeah, just as a matter of policy, I'd be in favor of having the video require attendees to have the video on the entire time. That's just my own opinion.
And that would be for synchronous online courses?
Yeah,
Okay.
that's just,
There could be a lot of people on the, so for example, if there's, I don't know, hundreds of people, sometimes the video capabilities don't work. I've experienced that. So
well, no, but that's the course provider's problem, not our problem.
that is true.
Am I missing?
That would be the course provider's responsibility.
So I appreciate the ask, and I think that you're on to something there. But in order for us to be consistent with the nation and the standard practices these days, it doesn't require you to have your camera on, but they have alternative ways of making sure that you're participating, like the polls, like clicking that you are still in attendance, those types of things. So as a measurement of your participation, having your video on is not one of the, say, standards. And so if we were to put that into our regulations, we'd be out of sync and possibly lose some vendors, some providers as a result. So that's the tricky part here. We want as many providers as possible. But at the same time, we want to make sure that those providers are providing quality. And Ms. Corrigan?
Well, just to add to that as well, and not that I'm sure about this or anything, but a lot of times the issue of video or not comes into privacy and that sort of thing. I think it's wonderful to know everybody's there, they're in attendance, they're learning, et cetera. And I've done the polls, how many of you, blah, 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 and you answer and they know you're participating. And then there's a separate, that's participation. Another one is I'm clicking, yes, I'm still here. And they do it frequently throughout the timing of whatever the course is. So they have kind of two ways of doing that, but we could be stepping into privacy claims. I don't know about that, but I do also, if you're finished, Mr. Rafel, I have a question for Ms. Benedict, and I want to thank you. It's a wonderful presentation, very thorough, and I appreciate that. I was just kind of curious, in my mind anyway, there's almost an assumption that virtually most CE is a part of the NASBA's National Registry, which of course it isn't, but I would think that the vast majority of the providers are, or does CBA often see some that are not on that registry?
We definitely see some that are not on the registry. I can't tell you exactly how many, like a breakdown of how many are on the registry, but it is very common for courses to be on the registry.
So my other question is, and I know how the CPE committee for NASBA works because I served on it a few years ago, and they're very thorough, and they've got a layering of approvals, et cetera, for those standards. So in the case of we have a provider that is not on that registry, are CBA staff looking to see that they are or they aren't? And then how are CBA staff determining that, this is qualified, they meet the standards, et cetera? This is a legitimate provider that we can rely on. How do you all do that?
We don't pre-approve courses other than the regulatory review course. We do have the right to look into a provider if we feel like there might be something that's not meeting our standards, but that would need to be brought to our attention in some way. They are allowed to offer their courses to CPAs without our approval before.
Okay.
Yeah.
Thank you.
I wanted to summarize the AI concern if I could. I might ask AI to generate a 50-minute course on professional standards with references and referrals to those standards in the text, along with footnoted references. And given it enough time, it will put together that course. The risk is that in the text, it will, they call it hallucinating. It will lie because it doesn't know the answer. Or it might refer to a professional standard in the footnote that just doesn't exist. So as a first start, first step, it's an incredibly efficient and time-saving way to start. But what's critical is the human interaction to make sure that what it's saying is true and anything that it refers to actually exists, and that what it's referring to is what it actually says in the footnote or reference document. And that's what's covered here in what's being proposed to us. Are there any more comments from the board? Oh, thank you, Ms. Lotta.
Thank you, Chair Aguilera. I was just going to make a motion to approve staff's recommendation.
And can I get a second? Ms. Hines, thank you.
I also had another comment, just about,
Let's get a second. And Mr. Raphael, you second, and are there any comments? Thank you, Ms. Hines.
yes. So just a reminder to everyone that this is directing the rules promulgation process. So we're letting staff know what we want to prioritize in the rules. So to Mr. Raffles' point, what's important to us is ensuring that participant engagement is prioritized and that there are several different methods by which the provider proves up or has the participant prove up that they are actually participating and engaged, and that there are efforts to thwart participants faking their participation in their engagement. So that's noted. That'll be noted by staff. Another issue that wanted to raise is about the time that it takes for the provider to provide certificates of completion. We put in a 60-day. The recommendation is a 60-day. And I wanted to recommend that a shorter period be considered, not a requirement, because, if it turns out that the providers, this is sort of a standard practice, that the 60 days is, what's required, and, shortening the amount of time to turn around a certificate of completion would, hamper our ability to make these rules attract the number of providers that we needed, but it feels like 60 days is a too long of a period of time for a licensee who was paid for a course to have to wait for their documentation. And it puts the burden or more of the, burden on the participant, the licensee, to do the follow-up as opposed to the provider who is collecting, fees for providing this service. So there was just something to, to note, I think, also in the research about what the regulations should require. But I'm not suggesting that we change the motion to reflect it. I just wanted to provide the comment, on the record that's something I think we should consider looking at.
Thank you.
Thank you, Ms. Hines. Any other board comments? Ms. Latta?
Thank you. I concur with Ms. Hines. It does say that existing regulation requires the CE course provider to issue a certificate upon completion. Is there a reason why we're now suggesting a longer period? Has that been an issue?
It has not been an issue to my knowledge. We're just aligning ourselves with the NASPA CE standards as much as possible, but we can certainly look at shortening up that time period.
Okay, I would agree with that, especially in our age where these certificates are digital, and it wouldn't seem too difficult for a course provider to be able to do that in a shorter time period.
Any other comments from the committee? Any public comment here in Burbank?
No.
Sorry, Jason Fox with the California Society of CPAs. Just a few comments. When we view continuing education, we value competency and learning outcomes over a compliance-based framework. And so generally, when we look at how we approach the learning from regulations and just practically how the profession operates, those are things that we value and try to incorporate in the content that we create. I think what the board staff has put together is reasonable and good, kind of best practices out there, certainly things that we're already doing internally and what we've seen from other quality providers. So supportive of that. With respect to the AI use, I think the president outlined a perfect use case example. Those were already happening in the marketplaces. Are things that we're doing, but you want to make sure you have the appropriate safeguards in place to make sure that there are, that human intervention to help kind of make sure there aren't any issues with that. So with that, we would certainly support the updates on this and continue to work with the board on the broader CPE kind of cleanup and reorganization. Thank you.
Thank you, Mr. Fox. Any other comments here in Burbank? Moderator, will you open up the lines for comments on this item online?
Certainly. If anyone online would like to make a comment, you may look for the hand icon and click that to raise your hand. If you're a call-in user, you may press *3 to raise your hand. Are there any comments on this issue? I do not see any raised hands. Shall I close public comment?
Yes, thank you.
You're welcome.
Ms. Reed, please take roll call.
Member Rayful,
Aye.
Member Lynn,
Aye.
Member Lotta,
Yes.
Member Hines,
Yes.
Member Corrigan,
Yes.
and Member Aguilera.
Yes.
The motion carries.
Thanks, Ms. Reed. Ms. Benedict, you're up again. Thank you. The next item is CBA item 14A. I'm sorry, 14B. It is our item number 4, discussion and possible action regarding continuing education hour requirements. I'll turn it back over to you, Ms. Benedict.
Thank you, Chair Aguilera. This item will focus on the total number of CE hours required for active renewal. The CPC and the CBA will be asked to discuss and provide staff direction on the CBA's participation in the emerging national discussion regarding reducing the number of CE hours required for active license renewal. This agenda aligns with Goal 2 of our strategic plan as noted on page 1. The standard CE requirements are listed on page 2 of the agenda item. CE requirements are based on work performed during the 2-year period immediately preceding license expiration, with a total of 80 hours required. As California prepares to join the national discussion on CPA's CE requirements, especially regarding the potential in lowering the number of CE hours, staff is providing the CBA with relevant information for consideration. The Uniform Accountancy Act, commonly referred to as the UAA, is jointly published by NASBA and AICPA and provides a model set of legislative language. The UAA Model Rules is published by NASBA and serves as a companion document to the UAA. The UAA Model Rules provide the state boards of accountancy with model language that can be used when drafting rules and regulations. Specifically, Model Rule 6-4 on page 4 provides recommendations for a CPA renewing in an active status, including an 80-hour CE requirement over a 2-year period. Staff solicited CE-related information from other state boards of accountancy through a NASBA quick poll and received a response from 28 of the 54 jurisdictions. For the remaining 26 state boards of accountancy, staff researched their CE laws and regulations. Staff found that most jurisdictions follow the model rules, with some exceptions. For instance, New York will allow 24 hours of CE per year instead of 40 hours if the CE is concentrated in one of their recognized subject areas. Also, Kentucky bases their CE hour requirement on how many hours a CPA worked and/or where they worked. Staff also researched the other boards and bureaus under the California Department of Consumer Affairs, referred to as DCA, to determine how CBA's CE requirements compare to other regulated licensed professionals. Staff found that the CBA requires more CE than all other DCA boards and bureaus, including surgeons, psychologists, and optometrists. Non-healing arts boards, except for the CBA, require less than 30 hours of CE every 2 years. Additionally, the Acupuncture Board was the only DCA board or bureau staff could identify that accepts non-technical CE. However, it is limited to 5 hours per renewal. A justification for change in the number of CE hours required would be necessary for a rulemaking package. A proposed change in the number of CE hours may require amendments to existing statutes prior to the rulemaking process. By participating in the national conversation, it will widen the CBA's perspective and could offer supporting rationale. Staff will continue to monitor the national discussions related to modernizing CE and will bring future items to the CBA as needed. Staff recommends the CBA provide feedback and direction on the CBA's participation in the national discussion that is emerging regarding reducing the number of CE hours required for active license renewal. This would include areas or points of discussion the CBA wishes staff to raise as part of the national dialogue. For example, the CBA may want to discuss what elements of the current CE requirement are most important to the protection of the public. It is important to note that the bulleted options on the bottom of page 5 are meant to spur conversation and are not representative of the universe of options that may be discussed as part of the national conversation. That concludes my presentation on this item. I will now turn it back over to Chair Aguilera, and I'm happy to answer any member questions.
Thank you, Ms. Benedict. And so I think what we're trying to do here is give feedback and ideas and and rationalization and justification. In a perfect world, there would be multiple peer-reviewed studies that show that 20 hours of continuing education each year is enough for a certified public accountant practicing public accountancy to maintain all standards and quality. That doesn't exist. So it's not like if your opinion is that it's something less than 80 hours, we really do need to have rationalization and justification. So for instance, if my opinion is that it should be 70 hours and not 80 hours, I really need to be able to provide rationale and support for why 70 hours is adequate. With that in mind, what are the thoughts of the committee members? Ms. Hines.
So one of the things that we can think about in our discussion is looking to other specialized professions, licensed specialized professions, and, you know, having staff take note. They did provide in the report, a reference to other professions and the number of continuing education hours that they require. Unfortunately, they are similarly situated in that there's not a lot of objective data that provides a correlation between the numbers and of CE that are required in the profession. So they looked at physicians and looking at lawyers and other, you know, licensed professions. But I do think that even looking to them, you know, we can extrapolate some, you know, some rationale for the importance of requiring continuing education hours, even if we are not able to come up with a, you know, a recommendation for what that number is. It's really important, I think, for us to lay the foundation for the national discussion about why we believe it's important for there to be continuing education that is required, and then identify some of the areas that we think are important. So for me, ethics within the profession is really important, and requiring practitioners to regularly, you know, engage in learning around how to practice ethically, not just what your ethics are in being a professional, but, you know, your judgment in utilizing the rules and interpreting the rules and in representing your clients. I think that's really important, an important value for us to, you know, to support and discuss openly, that we want to make sure that practitioners are regularly engaging and learning around ethical practice. Then beyond that, you know, maybe talking about the importance of practitioners having to stay abreast of emerging, you know, practices in certain specialized areas. You know, requiring that practitioners engage in a certain amount of continuing education to keep up their you know, practice areas and their understanding of the practice. So that's some of the information that we're looking to get from our committee, and then later on from the board. Like, why do we need continuing education? And if we can define why, then what are the areas of continuing education that we can define, we would prioritize? And then we can, you know, possibly start talking about, well, what's an appropriate number?
Ms. Corrigan?
Yes, thank you. You know, the 80-hour requirement goes back to, I have no idea when. It's been there a very, very long time. I don't know what the justification was, if there was any, or what analysis was performed all those years ago. I have no idea. I think some number, whatever it is important. It worries me a little bit when one of the jurisdictions kind of said, well, 0. Kind of leaving it to the licensee. Like, if I'm going to go out and do something specialized, and if I'm a responsible, ethical professional, I need to go bone up and learn all about that. And maybe a majority of the CPAs would do that. I can't be sure, but I know in enforcement, we see so many who just don't, or don't know, or aren't following, you know, changes in even compilation review, audit reports, procedures, planning, documentation, risk assessment, all of that. They just violate it. They just don't do it in spite of having an hours requirement. And of course, that's where enforcement goes to work and takes care of a lot of that for us. So I think some number is really important. I agree with what Ms. Hines said about ethics being kind of underlying a lot of, if not everything that we do. I'm leery to go to the extreme that one jurisdiction did. I would never support that kind of thing. I might support reducing, say, the non-technical, though there are some very important non-technical. And I suppose as a CP, if I need those, I should responsibly get those, but I wouldn't necessarily need them for licensing, depending on what we determine. So I do think something is important. I'm afraid to go down to like a bare minimum, whatever that might be, or say, yeah, we just don't need that. CPAs will just, police themselves and they'll be fine, because I don't believe that to be the case. Thank you.
Ms. Otta?
Thank you, Chair Aguilera. I have a few questions and then also some comments. In response to Ms. Corrigan's comments, I was also curious if we could potentially get information regarding the initial rationale for the 80 hours for the board. Okay, Ms. Centers nodding her head no. So, okay, thank you. I feel like that would be helpful just to know, but I guess it doesn't exist.
Mr. Frenzel?
Just quickly, before you continue, Ms. Center's right, at least in California, we don't have that rationalization. It's kind of been in place. I do know NASBA is attempting to the best of their ability to comb through the national information to try to find something. So if it does become available, obviously we will share it with you. But to the best of our knowledge, it seems to have just been there.
Okay, that's interesting. Good thing we're having this discussion then and kind of resetting that rationale. Okay, so another question I had is, and Ms. Corrigan referred to a few of these already. We noted that there's national conversations emerging. Ms. Corrigan mentioned one jurisdiction saying no hours are required. I was curious, do we know the overall theme so far? Can you illuminate some of the various conversations that have popped up so far?
It's still very preliminary, so I don't think there's a lot of conversations happening. Virginia did send out a quick poll, so they've kind of put the feelers out. There was another state, Minnesota, maybe, no?
North Carolina is doing a similar kind of exploration as well.
So yes, we're very much in the early stages where people are just kind of putting out feelers, and I don't believe there's any legislation or regulations being proposed in any state at this point.
Okay, thank you. My next question is, does changing our CE hour requirement, does that impact our mobility at all?
No, substantial equivalency and mobility are not related to CE.
Okay, great. Okay, and then I think overall, in terms of us kind of opening the conversation regarding rationale for reducing hours, I think one of the arguments could be there was no rationale established, or we don't have documentation of that. So that would be a good thing to note, that a reason why we are revisiting this topic. I think another thing that really stood out to me is this analysis with the other professional boards, which I really appreciate. I think that's something we all probably would have asked for. So thank you for being proactive and getting that information for us. I think it's just very telling to see that, professions who have human life in their hands, like surgeons and veterinarians who have animal and human life up to them, their requirement is from 36 to 50 hours. So I think it just illuminates that our requirement is just misaligned with all of the other professions. And we often have a funny saying in accounting that when things get very stressful, intense, that it's not brain surgery, we're not going to kill anyone. And so I just think it's interesting that it's kind of a wow to see that surgeons only have 50 hours and we're doing 80. And while our work is very important, I think it's just very obvious that this is a discussion that it's a good time to have and revisit the hours. I think I also would be in support of Ms. Corrigan's thoughts about potentially reducing the non-technical CE. While it is important and can enrich someone's career, it's not a requirement or something that's very critical for a CPA to continue their knowledge and profession and update their knowledge to make sure that they're functioning at the optimal competence to continue their career. So I think for now, it's where the conversation stands. That's where I'm kind of leaning for support as well. Thank you.
Thank you, Ms. Lotta. Any other comments? Yes, Ms. Hines?
So in looking at this and thinking about the fact that there is no evidence of of research or analysis as to why CEs and what's the appropriate number for the practice, and and looking at what other jurisdictions are doing to evaluate it, this might be, and because this is still an early conversation, And California has the opportunity to be a leader, you know, get in front of this issue. This might be appropriate for the board to appoint an ad hoc committee to do, you know, for a short period of time to do some research and analysis and then present a recommendation back to the board to guide the staff, because otherwise we are in this situation where the only time that we're able to really think and talk about it is during our board meetings. And our board meetings are really don't have adequate time for us to really dig into the information. And also we have to just rely upon what staff brings us. And then staff is only able to respond to the questions during the meetings. So, you know, if we had an ad hoc committee that was appointed to do some research on this and then come back to this committee and the board with some recommendations, that would allow that committee to work more closely with the staff and to, kind of drill down on some of these issues, that we've identified as being important to form as the basis for why CEs. Because I think that's really the essential question is, why CEs? And then after we, prove up that question, then what does it look like? So that's a recommendation, I'd like to, put to the committee to maybe take back to the larger board.
Thank you, Ms. Hines. Currently, Ms. Batchelor and I are on a CE work group, and that work group hasn't terminated yet. It seems like that might be the appropriate ad hoc committee that you're talking about to work with staff as necessary. And then the next level would be this committee, and then the ultimate level is the board.
Just process-wise, and Mr. Franzella and council can help us. Just process-wise, does the work group have is their charge sufficiently identified that we could, assign this? Or I think the president would have to assign that, or who appointed the work group, and is it a body that could, do this work? Like, just process-wise, is that the way that we would manage it?
It's one way you can manage it, and the work group provides a little bit more flexibility around the Bagley-Keene somewhat because only 2 members, and they can actively engage in discussions regularly without notice because they're just working through items, and then we're bringing those back to the board. And it's served this process particularly well. Mr. Aguilera and Ms. Batchelor were readily available, allowed staff to work with them, bounce ideas off them, aggregate data, get more information, and bring it back to this committee along the way. So I would say that's a good approach to continue to use.
My only concern then, though, is that a work group may not have the authority to put together a proposal or recommendation that could, because it's only 2 members and because it's not subject to the Bagley-Keene Act, they wouldn't have the authority to be able to, they could come back to this committee and report to this committee, but it still would be this committee that would be responsible for making the recommendations for the board to adopt. And I'm not saying it's good or it's bad. I'm just talking about what the limitations are. I mean, an ad hoc committee is more formal and it's subject to more rules, but it has its own independent authority to come directly to the board, not just to this committee, as opposed to maybe this work group because of the rules around it. It's more flexible, but it also has less authority. So I'm just talking through kind of weighing what's the most effective approach.
I don't think it has limited authority necessarily to bring forth a proposal to either the CPC or the board. But that said, if we did an ad hoc committee and it was subject to the Bagley-Keene, then members would have to make themselves available, and we'd have do the notices and go through that process. But I don't see any limitations with the work group being able to present a proposal to the board or to this committee for consideration and discussion.
One more process question, I'm sorry, and then I'll yield. Is an ad hoc committee subject to the same in-person quorum requirements as the under Bagley Keene?
If it's more than 3 people.
Yes, okay. So you still have to have a majority quorum present in person under Bagley Keene. I'm asking because the Brown Act is a little bit different when it comes to ad hoc committees. It allows for ad hoc committees to meet virtually without there having to be a person present in person. So I just wanted to just talk through, the difference.
So if I may, Mr. Chairman, those provisions also require, apply to state committees, as long as they're advisory committees. And in terms of exercising the authority of the board, whether it's an ad hoc committee, a work group, or this committee, they're all recommendations to the board, and only the board can exercise the board's authority. So how the board structures this process is really up to you. A lot of boards use 2-member committees as more working meetings. I've been part of some of those where it's really just the very basis of the discussions that are starting, and it's helpful to do it in that way, and then bring it forward into whether the committee or the full board, and that's where the public is able to participate and make comments. So I'm not sure if that helps you. So there's not a Bagley Keene legal issue here.
I don't have a firm opinion yet. My inclination is to an ad hoc because this is such a important issue. And I think we already have done a bit of the brainstorming and now we're talking about the work. It might be appropriate to recommend an ad hoc, but I'm putting out there the idea that we should assign this we should, deliberately assign this to a body to do some research and then come back to either this committee or to the full board, probably to this committee first, and let us talk about it and then make the recommendations to the board. Because I just feel like there's so many questions and there's so many ways and directions in which this can go. And I think it would be helpful to have someone to have the responsibility about defining where we're going. Sorry.
Ms. Corrigan?
Well, I don't understand necessarily the difference between ad hoc and what we have. I'll kind of leave that to the attorneys. And if you can explain that, I appreciate it. But I think it's important to know what the original charge for our work group was. And if it already encompasses this, why we just cannot continue along those lines. And it does seem appropriate they would report back to this committee. And of course, this committee reports to the full board for approval. So do we know what the original charge was?
I don't have it at my fingertip or in my memory. Sorry.
So to the best of my recollection, it was pretty expansive in terms of working with staff to kind of improve and enhance the continuing education requirements, and the breadth of what it wasn't limiting. Again, we primarily focused on our existing regulations and how to just improve the quality of the CE, just the readability of the regulations and some of those factors. But as part of those discussions, the workforce had already actually had an initial discussion on the number of hours, because it was one of those items that kind of fell under the breadth of what they were doing. We held off bringing it until now to have this discussion, because then it started percolating up on a national level as well. So I don't see any limitations to the original work group's direction or charge. And if we felt that we needed to just add on that we want you to continue to look at it for this particular purpose as well, the board is well within their ability to kind of provide that discretion. The 2-person work group just provides a lot of flexibility to staff, and I think to the board as a whole, because we can meet more regularly. And again, it's not doing things behind closed doors because everything eventually makes its way to the board or the CPC and the board for its final discussion. But we have more flexibility to perform the work on a more regular basis when we have the two-member approach than once we get to more that ad hoc or even a standing task force like we did for the attest experience requirement.
Okay, thank you. Then I just suggest we continue along those lines since that committee's or work group's commission has not been terminated by the board at this time.
Yeah, in our summary documents provided to us, it says the work group to develop proposals and ideas for CBA consideration. And the way that that's worked is over the last few meetings, those ideas and proposals have come through staff's presentation to this committee, which is voted to approve the recommendations. And then those have been, I think it might be called adopted by the board. Ms. Center?
I think as I was walking up here, Dominic said exactly what I was going to say, but I just want to make sure. So the work group did start conversations on the number of hours. So it isn't something that they were prohibited from discussing. We started those conversations, but as staff recognized that this conversation was going to happen nationally, as well as staff recognizing that there were some hour requirements within code, right? Not just in our regulations. So understanding that this might be a larger project, we kind of didn't carry on those conversations in detail and focused more on those things that we thought could be adjusted in regulations. So just to clarify, they have already started this conversation. They looked at the data that you looked at in this item. Both of them had comments on it. But I think that the work group would very much appreciate being engaged in that national conversation and being able to reflect on what they're hearing in those cases in order to come up with recommendations for consideration.
Mr. Franzella?
And thank you, Chair Aguilera. What Ms. Center just said reminded me of something that I want members to be mindful of as we continue down this process, is the hour discussion really will continue in probably its own kind of lane after we kind of get through this and even the next meeting when we deal with the CPE standards on the national scale, because those elements are the quality, the type of CE, how individuals obtain CE. It's less about, is it 40 hours, 60 hours, 80 hours? So at some point, probably even as early as after this meeting, these things will probably branch off a bit so that we can continue down the regulatory process and enhance the CE requirements and make them improve those while we continue discussions, because as Ms. Center pointed out, there's likely going to be a legislative aspect depending on how the board may come to the board, the nation, and everybody involved comes to some number, would likely require a statutory change. So I could see the number of hours being something that's just going to take a little bit longer. So we're going to continue to enhance the CE requirements while we have those discussions.
Ms. Hines?
So to be the directive and respond to the memo from staff, I would say, I recommend that we respond to staff's recommendation and give more direction to the work group to do, focus on specifically the questions of why CEs are necessary, whether or not CEs are necessary. And it's just feeling kind of like the, mobility discussion and some of the other, tasks that we've had to manage because it takes so long to get to a rulemaking process. I think this is an opportunity for us to start that process, and it may take us a couple of years to get there. So I think asking the work group more specifically, like to look into like why CEs, whether CEs are important, why they're important, identify some of the areas that that are relevant and necessary and important, and not necessarily to do the work about how many hours, but to come back with some perspective on a quantity of hours, to be part of that national discussion. And for the work group to, come back to this committee with a more formal proposal at some, later date, maybe not the next meeting, but maybe 2 meetings from now or something like that, like with staff's recommendation. But I think giving that work group some direction and then a specific, task to come back to the committee, I think I'd like to propose that we move in that direction. And then if there are other recommendations, I'm open to changing it.
Noted. Thank you. Ms. Lana?
Thank you. I just wanted to say that, or in response to Ms. Hines, why CE is necessary, mainly I think is because annually there's tax law changes. Periodically, there's audit standard changes or different accounting standard changes. So that's probably, for me, one of the foundational reasons why CE is required, so that CPAs can be up to date with that most current knowledge of whatever is changing that particular year. In addition, I think some feedback I have is possibly bringing back a summary of what the non-technical CE includes. I know we've seen it previously in different packets, but I think seeing that kind of summarized on a top level of the topics generally included as we continue this discussion would be helpful, especially since one of the recommendations is potentially eliminating those. So I think that would give us a clear direction as to if we feel comfortable with that or not. So I think that's what I have for now. Thank you.
Thank you, Ms. Lana. Any other comments? I'll say that in coming into this topic, I was pretty adamant about 80 hours is the right number. It's established. It's a differentiator in the profession. But I have been persuaded by my working group member, Ms. Batchelor, that possibly that 80 hours could be unreasonable when looked at with a fresh light, including no one knows where it came from, including that surgeons don't need as many hours as a CPA needs. And so I am now very open to reducing the 80-hour number to something more reasonable, and seeing that the other professions don't include non-technical subject areas, it seems like that's a great area for us to look at, whether that's really necessary or not. And so that's my current thinking. Are there any comments here in Burbank?
Jason Fox with the California Society of CPAs. A few comments, and this is a good conversation. I'll just underscore a comment I made a few minutes ago, is that, at least from the Cal CPA perspective, we value continuing education, and lifelong learning and competency, because we believe that's what makes a good professional, not because it meets a regulatory requirement. I mean, there's an important part of the aspect, but we want good qualified CPAs out there and learning that supports that. And so anytime we have a learning or requirement, we should think about what's the purpose of this and what are we adding to that professional and to any particular consumer protection aspect. This is a big conversation. I think you kind of noted that, there's a lot of different kind of aspects, but it shouldn't be taken lightly. And I think the conversation here, it sounds like the board understands the consequences around that. But in the spirit of this, the profession going through this kind of modernization and self-disruption, we just went through it on the education requirements for licensure, it does make sense to ask the question. And so, I think it's important for the board to be part of the conversations, whether that's here or nationally, other states. I agree California has the opportunity to lead here and kind of rethink what does continuing education mean in this space. And so I would encourage the board to be an active voice in that. I think as you approach the conversation, I think it might be helpful to kind of approach it in a framework to make sure you're being informed in the conversation. So, think about what data, research, other information you need to make an informed decision. And the staff has been doing a good job kind of capturing some of that thing, and some of the comments are kind of in the spirit of that. I do think it's important to engage others. I think the coordination is going to be key. We don't operate in a bubble here, particularly in California. We have licensees operating across different states and jurisdictions. And so getting licensee input, provider input, AICPA, NASBA, other state boards, I think is going to be helpful. I think you have to understand the implications around this related to the cross-border practice. While it's not a direct implication for mobility, there are potential implications related to what it might mean or other decisions state boards might make if we're out of whack or out of alignment with what other states or the national model is. So I think you have to take that into account. And then there are other regulatory and professional standards that have implications for continuing education, whether you're operating, doing yellow book governmental work. There are professional standard continuing education requirements that are independent of licensing requirements, same for public company work and whatnot. And so I think you have to kind of understand the implications of that. You might get rid of your requirement, but that doesn't mean that licensees aren't having to meet requirements for other purposes. And so I think understanding that is going to be important. And I would just, again, emphasize the competency and lifelong learning component of all of this kind of education, and kind of lean into that where it's possible. I mean, I think it would be a miss if the board just arbitrarily set a new hours or mix of requirements without really kind of thinking about all of the implications and kind of understanding what that means. So again, as we throw everything on the table, looking at continuing education, all the technical cleanup around the edges and the regulatory side, I think it does make sense to throw this on the table and have the conversation. But again, I think as Mr. Frinzella noted, this is a little bit of a separate animal. And so I think it requires the extra level of kind of due diligence and conversation and thought and whatnot. So thank you.
Thank you, Mr. Fox. Any more comments here in Burbank? Moderator, can you please open up the lines for any comments that anyone online might have on this agenda item?
Certainly. If anyone on WebEx would like to make a comment on this item, you can look for the hand icon, typically at the bottom of your WebEx screen. If you're on a mobile device, that hand icon might be behind the 3-dot other options. And if you are a call-in user, you can press *3. Are there any comments on this agenda item? I do not see any raised hands. Shall I close public comment?
Yes, thank you.
You're welcome.
And Ms. Benedict, a great job again today. Thank you. We move on to the next item 5, which is a discussion and possible action to amend the California Code of Regulations Title 16, multiple sections, add sections, and repeal sections, enhance licensure, and modernize mobility contingent on inaction of Assembly Bill 1175. We have Ms. Center here to brief us. Thank you.
Thank you, Chair Aguilera. Are you sure you're not supposed to read all those section numbers? I'm sorry, I couldn't help myself. Okay, I'll behave for the rest of my item. The purpose of this agenda item is to provide the board an opportunity to initiate a rulemaking to amend and adopt regulations. The vast majority of the proposed regulations address the implementation of board-sponsored Assembly Bill 1175. This agenda item aligns with goals 2 and 5 of our current strategic plan, and that is noted on page 1 of your materials. Before diving into the regulations themselves, I think it's helpful to point out the timing of certain aspects of the legislation. We provided each of you with a hard copy, looks like this, in your hand carry folder. This is also posted on our website. The first thing to notice is that the effective date of the new law would be January 1, 2026. That would be the effective date for everything that is not related to the enhanced examination licensure pathway. That would be things like modernizing mobility requirements and the clarification related to reciprocity. January 1, 2027 is when the enhanced examination and licensure pathway would be available to applicants. That provides the board with a year to do things like get the word out, update our internal processes, build applications that colleges and universities can use to get their degrees and certificates recognized. In 2027 and 2028, we will be accepting both the legacy pathway, which is our current pathway, and the enhanced pathway. The enhanced pathway, AB 1175 pathway. When January 1, 2029 comes around, we will only be accepting the enhanced pathway. Now that we have our timeline down and you have your cheat sheet in front of you, your blue timeline, we're going to turn our attention to the regulations themselves in your item. So toward the bottom of page 3, you'll see a bolded list of high-level items the proposed regulations address. I'm going to present a summary of the changes to each of the sections of the proposed regulations, skipping a few sections that only have minor changes. You should recognize the policy decisions made by this committee and the board when we review these regulations. I don't anticipate seeing looks of surprises on anyone's face. Please note the presentation does not specifically discuss each change to the regulations. Attachments 1 and 3, which contain the proposed regulations and the forms, should be relied upon for that purpose. So I'm going to be referring to attachment 1 as I go through my presentation. So if you want to follow along, please go to attachment 1, which is the set of proposed regulations. So section 5.5 on page 1 is proposed to be repealed. The repeal of this section is consistent with AB 1175 that eliminates the board's reliance on substantial equivalency. Section 6, which begins on page 2, is proposed to be amended. So if you turn your attention to page 2, line 44, through line 5 on page 3, you'll find a proposed definition in the form of a calculation of semester unit equivalents. Additionally, this section defines the terms institutions of higher education and person. These 3 definitions are relevant to all of Article 2 and remove the need to have repetitive language throughout the rest of the article. So if we now skip to section 6.1, oh, sorry, I'm going to skip section 6.1. We're going to go to 6.2. It begins on page 4. Section 6.2 is proposed to be added, so this is a new section. It clarifies the effective date for the enhanced exam and license requirements and an operative date for the legacy pathway. It also clarifies that applicants under the legacy requirement may not substitute any portion of their 1-year experience requirement. So we're going to skip to sections, we're going to skip sections 7.1 and 8.1 and move on to 8.2. That's on page 7. This section is proposed to be amended. The certificate of enrollment form that's used as part of our early entry program was modified to collect the degree the applicant is earning so that it can be compared against a list of board recognized degrees as part of the recognition process or expressway. We've kind of used that term with the board. Section 9, that begins on page 8, it's proposed to be added. It defines the education requirements for exam and licensing, including subject area definitions. Our subject areas are accounting, business related, and ethics, and a minimum unit requirements for that accounting concentration. The education requirements are the same for exam and licensing and mirror what the board approved in January 2025. Moving on to section 9.1, that begins on page 9. It's proposed to be amended. If you turn to page 10, line 23, you'll see instructions for the Credentials Evaluation Service to provide information on how electronic evaluations will be transmitted to the board. We added that. This requirement is also mirrored on the incorporated form. If you move on to page 11, line 15, you'll find an option for evaluation services to use an alternative disclaimer upon the board's written approval. The alternative disclaimer would indicate that they are not authorized to include opinions on course acceptance by the board or applicant qualifications on the evaluations. Section 9.2 on page 12 is proposed to be amended. Beginning on line 11 on page 12, the term legacy pathway is added to provide clarity in distinguishing between the current and proposed enhanced exam education requirements. A similar change is made elsewhere in the regulations. Line 38 adds the inoperative date of January 1, 2029 for the legacy requirements. So let's skip a bit and move on to section 9.4. That's on page 13, and this is also a new section that we're adding. Consistent with policies approved by the board in May 2025, this section addresses board recognition of degrees. Beginning on line 37 are criteria to earn board recognition. Starting on page 14, line 14, is the process for requesting recognition. If you look on page 15, line 10, the reasons the board may remove recognition of an accounting degree are listed. Those three areas are consistent with three areas that the board reviewed and approved in May 2025. Moving on to section 11, which begins on page 15. That section is proposed to be amended. This section has been amended to indicate the licensing legacy pathway education requirements are inoperative as of January 1, 2029. Section 11.1 begins on page 16. It's proposed to be amended. This section has been amended to include an operative date of January 1, 2029 for the accounting study education requirement. Let's go on to section 12. There is an end in sight to this presentation. Section 12 begins on page 17. It's proposed to be amended. So if you look at page 18, line 8, language has been added to clarify that the board has authority to require a supervising licensee to appear before the qualifications committee to substantiate the determinations made regarding an applicant's general accounting experience. The board may also request the applicant to appear in front of the QC. Moving to line 21, language has been added to clarify the settings in which qualifying experience may be gained, and these clarifications are consistent with current board policy. Beginning on line 23, section 12 outlines the experience substitution that may take place when an applicant earns an accounting-related advanced degree or board-recognized certificate. This is consistent with the policy that was approved by the board in May of 2025. Skipping a bit, we'll turn to page 20, section 12.2. This is a new section. This section is consistent with what the board approved in May of 2025. It addresses which advanced degrees will substitute for 1 year of the general accounting experience. Moving on to page 21, section 12.3. This is a new section. It is consistent with what the board approved in May of 2025 regarding board recognition of accounting certificates. So if you look at line 27, you'll see the criteria that an accounting certificate needs to earn the board recognition. And if you look at page 22, line 13, the process for requesting that recognition is outlined. Moving on to page 23, line 13, the reasons the board may remove recognition are listed. Those three areas of what you need, what you must agree to, and also reasons for removal are consistent with the areas that were reviewed and approved by the board. Section 12.5 begins on page 23 and is proposed to be amended. If you look at page 24, line 31, you'll see that the existing required attest functions are now expressed as job tasks. that is consistent with board-approved policy from May 2025. And edits to Form CAE 7 also address this change. Language on page 25, line 8 clarifies the settings in which qualifying attest experience may be gained. Next, beginning on line 15, language is added to clarify that completion of an accounting-related advanced degree or a board-recognized certificate will not qualify as attest experience. We're going to skip a couple sections and then move on to section 36.1, and that's on page 28. This section is proposed to be amended. It has been amended to require reciprocity licensing applicants to verify that they have provided attest services if they are seeking attest the authority for attest in their license. You can see this change on page 29, line 21. So staff recommend the CPC take the proposed motion as written in the item, which includes a contingency clause on the enactment of AB 1175. You do not need to read that. You can simply reference it unless you want to torture your chair and ask him to read it. So this concludes my presentation, but before I turn it back over to Chair Aguilera, I want to acknowledge and thank my staff and the multitude of stakeholders that provided input on the drafting of these regulations. From CPAs to college faculty, students, and Cal CPA, stakeholders were engaged. They were eager to give their input on the proposed policies, and I am very thankful for their continued support as we went through the bill and also these regulations. So with that, Chair Aguilera, I turn the discussion back to you.
Thank you. Great work. Are there any comments from the board or questions? I am looking for the page which would allow me to reference the motion. Yeah. Great, thanks. As you see on page 15 of 16 in the handout, there is a listing of regulations to be enacted or changes. And what we're looking for is a motion that would incorporate the documentation on page 15. That from Silverton. Thank you, Mr. Rayful. Second, please. Ms. Corrigan, thank you for the second.
I will second that.
Any comments? Yes, Ms. Hines.
Do we need to reference the contingent? Did we specifically? No. All right.
Any other committee comments? Seeing none. Any comments here in Burbank?
Jason Fox with the California Society of CPAs. For the record, we're supportive of the regulatory package. Just want to acknowledge the staff's very diligent work. A lot of moving pieces, a lot of different components tied to the legislation that's on the governor's desk and all the different pieces. And they've been great about getting good informed feedback. And so it's a good product and important to get this going as quickly as possible. So we'd support the board moving forward. Thank you.
Thank you, Mr. Fox. Seeing no other comments here in Burbank, Ms. Moderator, can you open up the lines for any public comments online?
Certainly. If anyone would like to make a comment on the issue or the motion, you may look for the hand icon, typically at the bottom of your WebEx screen, although our calling users may press *3 to raise their hand. Any comments on the issue? I do not see any raised hands. Shall I close public comment?
Yes, thank you.
You're welcome.
Ms. Reed, will you take roll, please?
Member Aguilera?
Yes.
Member Corrigan?
Yes.
Member Hines?
Yes.
Member Lotta,
Yes.
Member Lynn,
Yes.
Member Rayful.
Yes.
The motion carries.
Great. Thank you, Ms. Center and staff. It's an incredibly impressive process that's been put together, as well as the execution of that process over years through this committee and in a very organized and clear way. Thank you so much. We'll move on to our next agenda item, discussion and possible action regarding alternative practice structures presented by Mr. Franzella.
Thank you, Chair Aguilera. Good morning, members. So for this item, the CBA is being asked to provide input and direction. Geez, wow, that's really loud. Input and direction on national discussions regarding alternative practice structures, which is commonly referred to as APS, particularly those APS involving private equity. This issue is really gaining a lot of urgency nationally due to the rapid expansion of PE-backed APS models and some potential concerns or considerations for independence, governance, and consumer protection. One thing we want to, or we hope to accomplish with this item is first a bit of level setting regarding APS and PE investment in APS. Hopefully this will assist the CBA in providing feedback that leadership, members, and I can share with various stakeholders as part of these ongoing national discussions. And as we go through this agenda item, I do want to preface that by no means am I really, and nobody on our team necessarily experts in this topic, but we are constantly educating ourselves so we can be providing as much meaningful information to members as when we meet. So as highlighted in the background section on page 1, historically CPA firm ownership was limited to CPAs, but over time, that structure's evolved to include both non-licensee owners and what's called APS models. And while California doesn't have a definition regarding APS, the AICPA Code of Professional Conduct, which California requires the CPAs and CPA firms to comply with, defines APS as a structure where a CPA firm providing test services is closely aligned with a non-CPA entity offering other professional services. So practically, what does this really mean, and how does APS with a PE-backed non-attest entity operate? In essence, the CPA firm will split itself to create two different operational structures, one which will continue to be a licensed CPA firm, and one which will no longer be licensed. The organizations generally operate under a similar brand name, but are formed under different organizational structures. The licensed CPA firm is commonly and often referred to as the attest firm. And the attest firm continues to be licensed by the state boards of accountancy, must continue to meet with any of the firm ownership structures required by the boards, and provides the attest and assurance services. Conversely, the non-attest entity provides all the non-attest professional services, including services such as tax, consulting, management, and advisory. And this ownership structure for these non-attest entities varies. They might be wholly or partially owned by PE. They might have CPA owners and CPA partners from the attest firm as owners as well. But this entity is not licensed by boards of accountancy. The attest firm and the non-attest entity operate under a wide-ranging administrative services agreement, and this agreement, in essence, creates sort of a symbiotic relationship whereby the non-attest entity provides centralized administrative functions to the attest firm, including items such as human resources, staffing, IT, marketing, and just general office administration. So oftentimes there's a question of why over the past few years the profession has seen a growing rise in PE-backed APS, and items such as access to capital for technology and AI and geographic service expansion, talent acquisition and retention, operational efficiencies and strategic advantages through PE expertise and succession planning support for retiring partners are a lot of the items given as to why PE is attractive to the CPA firms. As for concerns being raised by stakeholders, including regulators, these include independence and objectivity, concerns about PE's profit motives may pressure audit judgment or create conflicts of interest, governance. This dual entity structure can obscure who controls the attest firm. Consumer transparency, clients may not clearly understand which entity is licensed or regulated. And cross-border practice, APS firms often operate across multiple jurisdictions, complicating oversight. So on the national stage, stakeholders are actively discussing this topic. The AICPA, through one of its committees called the Professional Ethics Executive Committee, or PEAC, is reviewing updates to the Code of Professional Conduct. And furthermore, PEAC has even established a subcommittee called the Alternative Practice Structures Task Force to determine whether a PE investment in the non-attest entity of an APS creates a need for revisions to the code or need for non-authoritative guidance. This group issued a discussion memo back in March of this year, and an exposure draft is expected probably in November. And we've actually attached the discussion memorandum to this item, the one that was issued back in March. Excuse me. As for NASBA, Chair Maria Caldwell appointed the Private Equity Task Force to evaluate the implications of PE investment in CPA firms and identify ways to support state boards in their oversight responsibilities. Chair Caldwell has actually appointed me to the NASBA Task Force, and I've highlighted the other members on pages 5 and 6 of your materials. To date, we've held 4 meetings with another one scheduled next week. Our first deliverable to hopefully issue a white paper to help other regulators get acclimated to the topic, which we anticipate getting out prior to the NASBA annual meeting in October. So with all that set up a bit, I'd like to cover and direct members' attention to the middle of page 6, where staff have a subsection titled Possible Topics of CBA Consideration, or Possible Topics of Consideration for CBA. Again, I'd like to stress that what staff wants to ensure that there's a collective view coming from the CBA being shared on the national discussions regarding this topic. And staff have highlighted some topics members may wish to consider and may wish to mirror topics discussed in this earlier presentation of the paper. First relates to independence, objectivity, and governance. As I mentioned, the AICPA is looking at updating the code. The AICPA is considering a combination of updates that are both what are termed as authoritative and non-authoritative in nature. And the AICPA is also considering an abbreviated comment period for the exposure draft. Staff believe it will be important for the CBA to have an opportunity to review and possibly comment on this exposure draft. And as part of the ongoing discussions regarding this upcoming exposure draft, the CBA may wish to note 2 items for the AICPA consideration. First, PEAC should make every effort to adopt the updates via authoritative guidance. As regulators, the CBA can only enforce those aspects of the code that are authoritative in nature. And secondly, PEAC should not shorten the comment period for expedited purposes without sufficient time to analyze the updates. Coupled with the timing of a CBA meetings, the comment period may elapse before there'd be an opportunity to comment. The next topic staff highlighted is on the middle of page 7, related to consumer protection and transparency. Given how many of these APS firms market themselves, especially via their respective websites, consumers may be unclear about which entity they are engaging with, specifically which is licensed and regulated, the attest firm, and which is not, the non-attest entity. The CBA may wish to support increased transparency in website content and consumer-facing disclosures. The last topic is on the bottom of page 7, and it continues on to the top of page 8, related to cross-border practice and jurisdictional issues. Again, APS entities operate across multiple jurisdictions, with many having national presence. One of the main issues we've been seeing crop up is the use of the CPA title or use of CPA designation. We've heard that some APS firm leadership instruct employees not to use their CPA designation in any public-facing materials, including their personal social media profiles. The CBA may wish to advocate for a modernization of the use of title. So on page 8, we've laid out 3 factors that could support the idea for modernizing the use of title. First, CPA pipeline, as all the members are aware, and we just kind of went over in our last agenda item. Regulators and the accounting profession have been working to find solutions to the CPA pipeline for multiple years now. And for CBA, this is manifested itself out through the CBA sponsoring AB 1175 to create more appropriate minimum standards and flexible pathways to the licensure. If individuals are not encouraged or, in fact, allowed by employers to display the CPA designation, this could adversely impact future professionals from seeking licensure. Second, just consumer understanding. When individuals who have earned the CPA license can display the designation, consumers are afforded greater understanding regarding these individuals' backgrounds. Consumers can review state boards of accountancy websites to understand the regulatory framework, how individuals obtain licensure, can review online records, and which include prior enforcement information. And consumers now have know a place to file a complaint should the need arise. And third, CPA designation and use of title laws. Most state laws surrounding the use of CPA designation were written before the advent of the internet. Most likely they were written with yellow pages in mind. I believe ours were written back in the 60s related to the use of title. So definitely prior to the internet and definitely prior to the advent of social media, there is likely a need to consider evaluating how the use of title can be modernized to allow individuals to use their CPA designation more freely. So staff recommend that the CBA evaluate these topics along with any CBA developed topics to establish a list of ideas, topics, issues, concerns for CBA leadership members and myself to share with stakeholders as we continue to take part in future national discussions. So with that, I'll turn this back over to the committee and Chair Aguilera, and I'll do my best to answer any members' questions.
Thank you, Mr. Franzella, and congratulations on your NASBA appointment to the Private Equity Task Force. I'm sorry. To our benefit, though, to have a seat at the table, both to provide California's viewpoints as well as to report back to the board and the consumers in California about this emerging topic. So thank you for your efforts here, and thank you for starting us on this discussion. And what I understand is that you're looking for feedback on us for all of the topics that you just discussed, and or anything else that's peripherally related. Are there any comments from the committee members? Ms. Hines?
I want to commend you, Mr. Franzella, on this presentation, because this is really complicated, very dense information to process. And for me, it was particularly, and I think you did it very well. Where I have a challenge is as a person who doesn't practice accounting, this is where I don't have a real appreciation or understanding of how this issue impacts the industry. But, because of my responsibility to protecting consumers, it is important, for me to to try to gain additional, context. And one of the things I would ask is, as you're engaged in this work, is identifying some professionals that are, folks that are leaders on this topic, like you provided the listing of resources of folks who have written articles about, this topic. I think it would be helpful to have, maybe invite some folks to come in and make presentations to the Board of Accountancy about this issue, because it's one thing to read, articles and white papers and things like that. But it's another thing to have, just a different way of taking in the information. Someone who comes in with a presentation and provides some examples or scenarios that, represent some of the issues that we're facing. Also, there are some concerns, issues that are presented that are like theoretical. And, it would be helpful to kind of flush out what are the issues that are, likely to happen, as opposed to issues that may be just fears that we have about the unknown, but are not necessarily realistic, or where that fear may become barriers to us being able to make really reasoned decisions, or where our fears are preventing us from evolving, because the comfortable is easier to sort of work with than the unknown. So thank you again for bringing all this information to our attention. Thank you for your continued engagement on this issue, and then any other ways that you can bring information to us that's not just a really nice nighttime reading packet would be much appreciated as well.
Hines, any other comments? Mr. Rayful?
I'm even less of this is, as a public member, this is more confusing to me than it is Ms. Hines, who's actually licensed. But I was curious about what it says, the last thing you talked about on page 8. If you look online and you're looking for a restaurant, what they say is rated one of the top 100 restaurants in Los Angeles. If you're looking for an attorney, one of the top 100 attorneys. Why would a company tell their CPAs that they don't want to advertise who they are? But more to the point, wouldn't it be, what are you trying to hide if you're not saying to the public in social media or internet that your staff person is not a licensee? I mean, isn't that sort of antithetical to what we're trying to do as consumer protection?
Mr. Franzella?
Thank you. So I'll speak more anecdotally from what I've heard as to why the firms or the non-attest side, the non-attest entities and the leadership and that governance structure is encouraging or is directing their professionals to not use their CPA designation, is kind of operating from a path of worst case scenario. And this gets back to the CPA designation not being regulated nationally in a consistent way. So these firms are operating in a national environment across multiple states, and not every state regulates the use of title the same way. So if, say, you're I can speak to one in particular, North Carolina is a use of title designation state. So if you put CPA in anything, you have to be registered as a firm in certain instances. And so that would trigger a firm registration just by having those individuals put their name behind it. Whereas in California, that wouldn't necessarily be the case. So they're operating from this path of what's the most restrictive model, and then building their structure around that. So yes, I think they would probably be more encouraged if they felt that the use of title wasn't going to somehow trigger certain type of regulatory structures for their firm.
Are they concerned about, I mean, is it a liability question? Are they concerned about liability? If they have a CPA who does something wrong, and then not only is the CPA censured, but the firm is censured? I mean, what I'm getting at is, what are they trying to hide?
I don't know if it's a matter of really trying to hide. It's more of those non-attest entities otherwise in most states may not be required to be registered. But if they have CPAs holding out as CPAs, then they would require registration and would subject them to a regulation that otherwise they would not be in every other state. So I'm not sure they're trying to hide. I just think they're trying to go forward with a regulatory structure where they're not otherwise needing to be licensed. And so by removing that CPA designation option for their staff, they're not having to register their firm or that non-attest entity with the state board.
Thank you.
Ms. Hines?
I don't know that it's necessarily, I'm just speculating myself, but it may not necessarily be that they're trying to hide something. It may be that there's not, because the laws haven't caught up to this new area, rather than doing something and then being subjected to questions or, an issue coming up, it's easier to wait and let it work itself out than it is for them to, kind of be the first, so if you were to, use your CPA designation in this manner and, and I imagine some of this is coming up because of of this, mobility issue. And like, there's an evolution of like where, industries are able to practice and they're not just, focused on one area. They're, focused on multiple jurisdictions. And if all the jurisdictions have different laws and rules, and it's hard to be able to practice in a way that meets all of the regulations, you might be inclined to just stay back and not implicate yourself in that, environment until there have been some rules that are, more established. I'm just cautioning on, seeing a malintent in their intention to not, to not use the designation. I think your question is also an example of why it would be helpful to have some presentation or a panel or something like that, that we could hear from the practitioners or from the folks that are involved in these areas so that, we can hear firsthand from them what are some of the issues that they're facing and why this alternative practice, environment is beneficial. I mean, I think it's hard for us to really get a real answer, without hearing from those folks, from the folks that are practicing in these areas.
Ms. Corrigan?
Thank you. We definitely need to understand that better, understand the reasoning behind that. And I'm wondering too, under the PE entity, it's my understanding, but correct me if I'm wrong about that, that the staff are lent, leased, whatever it is, over to the attest firm to perform the work, that CPA partners are part of the attest firm, and then the staff move over to do that work. Is that correct, Mr. Franzella?
Yes, that goes back to the concept earlier in the paper about an administrative, or sometimes they're called administrative service agreements or shared service agreements. Really, the CPA firm or the attest entity, really the extent of their, I guess their equity is, or capital in some respects, is just the license. Everything else, the buildings, the staff, the IT, all those other resources are owned by the non-attest entity, and that shared service agreement lends them back. And so that's where some of the earlier discussion is where Peak is looking at through the independence, governance, objectivity piece to make sure that that real and perceived threats are being evaluated in terms of the attest services.
I have a few more are ready to kind of discuss, but I think Ms. Lotta may have something to add.
Thank you, Ms. Corrigan. I just wanted to kind of circle back to our discussion about the CPA title designation and some of the notes in our packet of topics we could consider to support. In regards to the CPA pipeline being negatively impacted by these APS firms not allowing employees to display their CPA designation. I think that could definitely be something that happens, especially we already have pipeline challenges, and I think that could diminish the value of the license in the eyes of a CPA candidate or an accounting graduate. So I would agree with that. And, you know, we work so hard to get our CPA license. So I think it would be a shame for that to be an overall trend or something that continues and is something we should definitely address and try to work to modernize the use of title to make it clear, I guess, for these firms to know, like, if it's okay for them to use that or what the guidelines are for them to use that. I think it's very important to get to that point for that purpose. And I also had a comment regarding the consumer transparency. I do agree that we should work to push for more transparency in those designations and those marketing materials as well. And then lastly, in regards to the exposure draft coming out, I would also support not shortening the comment period. I think it is important to just have whatever the standard comment period time is available for our board and other boards to be able to respond. Thank you.
Thanks, Ms. Lotta. Ms. Corrigan?
Yes, thank you. So as it pertains to, well, there were 4 bullet points and we addressed 3 in here. The independence, objectivity, and governance definitely is critical. I support comments in here from Mr. Franzella and staff that that needs to be underlying in everything that we do. And as far as Peak making every effort to adopt the updates and what Ms. Lotta said, I would not want to shorten or quicken or rush to the finish line on something that's so crucial. They need to give adequate time for boards, you know, to respond, and it needs to be very thoroughly put together. I guess the one bullet point I didn't see continue over here was the governance, and I'm not really sure why, Mr. Franzella, but I think it's important not to obscure who truly governs what's happening, and especially the attest function, who's responsible, that sort of thing. So I think that's important, as well as the cross-border practice jurisdictional issues are very critical. And I'm basically concurring with what staff has presented in here and not shortening the response time. I too have been in positions where I have heard where CPAs are being encouraged not to show their licensing, not to make their licensing apparent. And that bothers me a great deal. So those are my comments. Thank you.
Thank you for your presentation again. And there are a couple of items that come to mind for me, which is independence. So audits, if a private equity firm has a relationship with an auditing firm, or then that relationship might be an affiliation, it might be an investment, it might be ownership. So is an affiliation, rise to the same level of concern as ownership? Maybe not, but I would still have concern that an entity that has an affiliation with an auditing firm hires that auditing firm to audit either the core entity or its subsidiaries or sister companies. And so I really like the idea of continuing to study that and then ensuring that I think it's the CPPE committee of the AICPA, when they come to conclusions that protects against that independence compromise, that it does end up in the code of professional conduct. So then we have something to regulate against. I think it's a long process, but that seems like a good process. And then secondly, with regards to the CPA certification and making that known, it's sort of a funny situation here because It's always been, if you're going to hold yourself out as a CPA, you have to meet all of these regulations. But this is the counter argument, and that I'm a CPA, but I'm not going to let anybody know. So in the extreme, we could change the regulations that says that if you're a licensed CPA, you must, have it on all your letterhead and make all your clients know that you're a licensed CPA. I think that might have a chilling effect. And so what my hopes are is that, and I bet this is a close call for a lot of these entities, or any entity that decides not to hold themselves out as CPAs or have their staff hold them out as CPAs, a close call between the benefit of being a CPA versus the detriment of having to follow regulations that are unclear. So hopefully in the long path is that the regulations will have clarity, they'll be acceptable to everyone, and there will be no need to hide the fact that I'm a licensed CPA in California. Thanks again for putting this all together. Are there any other comments from the committee? Seeing none, are there any comments here in Burbank?
Jason Fox of the California Society of CPAs. You guys just have quite the extensive agenda this morning. This is certainly a very important conversation, and it is top of mind in almost every conversation we're having with our licensees nationally, with other stakeholders. So I do want to thank the staff for bringing it forward to the board in a thoughtful, kind of informed manner. It is a good outline of the conversation. I think firms are certainly, feeling pressure. Talent and people are expensive. New technology is expensive. New service lines to meet consumer and regulatory demands is expensive. And so as they look at kind of how do they modernize, restructure themselves, find the capital and resources to be able to do that, this is a trend that I think is going to continue over the next few years. And so, you start to see the pressure points in a, kind of a legacy regulatory model where there are pain points about confusion, as Mr. Aguilera noted, around when can I use my title, what does it mean in what state, another state, different service lines, all that sort of stuff. And so these are very real conversations, and I think it's important as the profession, regulators here in California, nationally, all get together and have an informed conversation on this. I'm very eager to see what comes out of the NASBA white paper and what that, comments and feedback on that is. So I'd encourage the board to kind of stay engaged in this conversation, stay engaged in the national conversation, and I don't think it requires any, immediate jump to a decision point, but I think it's going to require, a little bit of a foresight and kind of be part of that big conversation. And so I just want to note that in there. It is very real and it's an important conversation. Thank you.
Thank you, Mr. Fox. And I am reminded here that a source of capital for the public accounting firms can be a good thing in terms of consumer protection, meaning that there will be funding for modernizations, funding for buying out of equity partners, funding for other enhancements to these public accounting practices. Thank you. Seeing no other comments here in Burbank, are there any comments online, Ms. Moderator?
Thank you. This is the moderator. If anyone would like to make a comment on the issue, you may look for the hand icon, typically at the bottom of your WebEx screen. If you're on a mobile device, that hand icon might be behind the 3-dot other options, and our call-in users can press *3 to raise their hands. Any comments on the issue? I do not see any hands raised. Shall I close public comment?
Yes, thank you.
You're welcome.
And so I appreciate this committee's hard work, all of the pre-reading and all of the hard work that staff has done. And with that, we are adjourned.